up in the middle of the night for the last 2 weeks, thinking about the future of our country, the safety of our families, and what steps we need to take as LGBTQ families to take care of one another. Today is also Transgender Day of Remembrance during Transgender Week of Visibility, which are important days to recognize the courage of our transgender family and friends and the important work to make the vision of transgender joy and safety a reality for all. I'm particularly aware of the vulnerability our transgender family and friends are feeling today. And all of that is why I'm so excited and grateful that you've joined us for this amazing panel of experts from the leading LGBTQ groups across the country who are and have been dedicated to protecting LGBTQ families, couples, and people for decades. I know that you have questions, and this is truly the dream team of experts. So I'm going to quickly introduce our panelists and share how our time will go. First is Shannon Minter, who is the Vice President of Legal at NCLR. Shannon was the lead counsel for same-sex couples in the landmark California marriage equality case, which held that same-sex couples have the fundamental right to marry, and has had a long career in advancing equality for LGBTQ people, including trans people. Shannon will be providing some context about this moment for our families and then facilitating the conversation amongst our other panelists. Those panelists are Mary Bonauto, who is the Senior Director of Civil Rights and Legal Strategies at GLAAD Law. Since 1990, when Mary joined GLAAD Law, she has litigated and done policy work in every New England state and beyond on the full matter of issues that affect LGBTQ people's well-beings and rights. In 2003, she and GLAAD Law argued before the in 2003, she and GLAAD Law won the first freedom to marry case in Massachusetts. And in 2015, she successfully argued the US Supreme Court case, Obergefell v. Hodges, which established marriage equality nationwide. In between, GLAAD Law won or partnered to win marriage cases in state courts, in state legislatures, and at the ballot box, and filed the first successful challenge to the Federal Defense of Marriage Act. GLAAD Law has worked intensively on the provisions of the Respect for Marriage Act, which was signed into law 2 years ago this month. As you can imagine, Mary will be talking about marriage protections and what couples should know. Meg York is the director of LGBTQ plus law, family law and policy, and senior policy counsel at Family Equality, where she works to advance protections for our families. Meg brings deep experience in family law. Meg will be discussing parentage protections and how LGBTQ families should think about next steps. Finally, Nesta Johnson is a family law attorney at NCLR, where she works on the intersections of LGBTQ plus rights, racial justice, economic justice, and disability justice, all to advance the right of LGBTQ parents, parents of LGBTQ children, and single and multi-parent families. Nesta is going to focus on the questions we received about transgender people and transgender parents. We've collected many questions from you when you registered, but feel free to use the Q&A feature as we go along, and we'll get to as many questions as we can. And a reminder, this webinar is being recorded, and we will be sharing resources and the recording after the event. Now over to Shannon.
Thanks, Naomi. And I don't need to take much time providing context because I think we all kind of know the context mostly, but I do want to just say one thing, and that is it's an honor to be on here with all of you, but Mary, it is particularly an honor to be on here with you. And I know I speak for our whole community in expressing enormous heartfelt gratitude to you for the decades of work you've done to create marriage equality, to create the Respect for Marriage Act, and that you're not just walking away now. Thank you for not for hanging in with us through yet another twist and turn of this ongoing saga of trying to protect our families. Yeah, also, I think everyone on here knows very well the context. Supreme Court in Dobbs, Clarence Thomas said that he wishes they would overturn Obergefell. That was terrifying. We've been in the middle of a mounting anti-LGBT backlash. We've got statements from the incoming president, his campaign, this Project 2025, which talked a lot about undermining marriage equality and just absolutely shredding any kind of protections for transgender people. The RNC platform had horrifying measures in it, particularly, again, targeted transgender people. We know from the first administration and experience with the transgender military ban and some other matters, this is our incoming president, someone who does the horrible things that he says he's going to do. So we need to expect that. We learned a lot, but I can't stress enough. There's no reason to panic around these family issues. We can absolutely protect our families. They want us to panic. They want us to feel paralyzed with, helplessness. There's no reason to do that at all. There's some things that I am really honestly pretty scared about. Our ability to protect our families is really not one of them. I think I know there are steps we can take to do that. There really are, and they're gonna work. So, and I know that's the whole point of this whole show here. So I'm just gonna get started. And Mary, we are starting with you, and people do have some questions that we know about marriage. Which the first one is just, if I'm currently married, do I need to do anything? And then a little bit more specifically, if I live in a state that still has on the books a ban on marriage, do I need, or state's going to have to recognize my marriage if Obergefell gets overturned?
Thank you for that. Those are really sensible questions to be asking in these times, which, as you noted, are unprecedented, not only on, well, attacks directly against our community, but on a lot of communities. And I get that people are really worried right now, and understandably so. And I just have to say, like, Shannon, right back at you and everybody else on the call on marriage, and we all did it together. And that's how we're gonna keep winning too, is by working together. So thank you. And with respect to that question, do I need to do anything? Yeah, like, you got married. So that's great, right? That's a big protection in and of itself. So it's not mandatory, of course, but you did it, and that is a protection. I'm sort of a document person. So if it were me, or I already have, get some certified copies of my marriage certificate and maybe put one in a fireproof box kind of thing, just so you have that. Like, you may get to a point at sometime that you need to actually prove your marriage. I don't know, but like, it doesn't hurt to have the document, right? So I would say that. Another thing that I would do is say, like, if you live in a state that doesn't respect a marriage, like, again, I just want to be really clear, it would be absolutely outrageous to reverse Obergefell. There is no reason to do so. It's a mainstream legal decision. It's equal protection. It's due process based on cases that go into the 1800s. Like, come on. So there's that. But then there's also just the fact that when you marry, you are making a commitment to somebody that's a legal commitment and has enormous effects legally and socially. And it's something you carry with you day in and day out. And it really, like, eases people's way in forming families, owning property, ordering their lives. And a lot of other institutions are counting on those marriages too. The employers who say, okay, check, this is who's going to get the benefits here. The employers, the healthcare providers, the schools your kids go to, the insurers, like, on and on. And it would be so disruptive to revisit this so-called, i.e. reverse it. And so I would like to think that the Supreme Court wouldn't even take a case. Like, it's just that much of a slam dunk, especially because they take so few cases as it is. They get, at least 10 times more than 10 times more petitions from the court to the court to take a case than they ever accept. No reason to do this. No reason to disrupt something that works. No reason, and this is something that has harmed no one. So I just want to put that out there. So in terms of what your rights are, should there be this, like, unimaginable thing that happens, that I think we should not let happen. But assuming that kind of thing were to happen, then what I would say is, this is where the Respect for Marriage Act comes in. The Respect for Marriage Act, has, well, number one, it starts out, and as you know, this is like a bipartisan effort, Democrats and Republicans from the beginning. So unusual in Washington. So it was a bipartisan effort from the beginning and through to the end, through the votes in the House and in the US Senate. And it started with the idea that marriage is so important to anybody who's married that they need to be able to count on that stability and security for the couple, for any children they may have, and it shouldn't be disrupted. And that's why it's called the Respect for Marriage Act. We are going to respect existing marriages. And so one substantive part of it has to do with states. And it says essentially it says two things there, but one is, if you are a state actor, like you're acting for the government in your state or locality, you cannot deny protection to a marriage or treat somebody as unmarried because of the sex, race, ethnicity, or national origin of anybody in the marriage. Like that can't be your reason. And even if your state law is different now because something has changed, you know, in the federal landscape with Obergefell, still, that is not an excuse for mistreating people who are married to a person of the same sex or otherwise. So that's extremely important. It also, by the way, expressly uses Congress's power under the Full Faith and Credit Clause to say acts, records, judicial proceedings, all of those have to be respected. And you again can't use sex, race, national origin, ethnicity as a basis for saying we're not going to respect that particular marriage. So that's huge. That is really huge. And I want to say it takes like 60 votes, at least at the moment, to be able to get anything through the Senate. So I'd like to think that law is going to stick around. The second thing I wanted to say that the Respect for Marriage Act did is it codified the ruling from United States versus Windsor, you know, which was an equal protection holding saying you can't have all of these marital duties and protections under federal law, over 1,300 of them, and then just say one class of people gets none of them, right? And that equal protection ruling was very, very strong. And the United States Congress said, yeah, we're going to codify that. You know, there should be a rule of equal treatment. They were concerned about this, this issue of marriages potentially being mistreated and people being mistreated. So those are the protections that you have if you are in a state or you move to a state that does not respect your marriage. And I think it's going to be really important for people. Will it get tested? Yeah, but you know, we're going to be there on this.
Mary, what about if you're married out of the country? Does that pose any special problems or issues for people?
Yeah, good question also. I mean, because a lot of people do marry outside of the country, and the general rule is, yeah, if you join in a marriage that's, you know, the kind of marriage that could happen in a state here, so it's going to be two people and, you know, whatever it might be, like, yeah, then that's okay. It's going to be respected. That's the general rule. So you know, you can always talk to more people about it, but I think that's should provide people some comfort. That's been the general rule.
Yeah, good. Yeah, that's my understanding too. So this one, I know we're all getting this question. People are asking, you know, if I've been thinking about getting married, is there some reason that we should hurry up and get married now before there's some sort of, you know, negative development under the new administration?
You know, I feel like it's a very much of a personal decision and it has to be right for you at the time. So I wouldn't say like, hurry, go marry, you know, it's up to you. And if you do, so anyway, but you know, so in terms of thinking about the timeline of something bad happening, again, I think that timeline should be never. And I think we should work to make it never and make sure they never take a case. However, you know, bear in mind, like they reverse the Respect for Marriage Act, it doesn't make marriage go away. Reversing Obergefell is going to take a lot of work, and it's only reversing Obergefell, and only the Supreme Court can do it. That would change things. So I think do it on your own timeline, but again, marriage is a protection, and if you find that compelling, then yeah, think about it.
Now, you know, in the past, we've told people that even if you're married, it's a good practice to have like power of attorney for medical decision making and finances and other like basic relationship protection documents just in case you run into any problems. Do you think that's still important? Is it newly important? Would we still recommend that?
We do it, Glad, and I do in my personal life. Absolutely. I feel like, you know, we all have lived with enough horror stories out there over the years. Sometimes we were able to do something and sometimes we were not. And having those kinds of documents that aren't contingent on what somebody feels about you and your marriage is probably a good thing. You know, documents that are healthcare proxies or medical powers of attorney or financial powers of attorney are familiar. They should be respected. Again, anything is possible. But yes, I would absolutely recommend that people still take those efforts.
And this question is one that comes up all the time too, and it's come up in the past too. It's not a new question, but is being married enough to protect our kids?
Well, here's the thing. Like, as I said, marriage is a protection and that there's a marital presumption around parentage. So if you have your children within a marriage, it's presumed that you're both parents. You both go on the birth certificate, and that's a protection that starts at birth, and that's important. Okay, so that is something, but is it enough? That's where I would recommend that people remember that there is discrimination out there, as though you have forgotten, right? And that you do the other things you can do, just like we were talking about, powers of attorney and healthcare proxies. And I'll turn that over to someone else.
Yeah, Meg, do you want to talk a little bit about like how people can best make sure they have a legally protected relationship with their children, married or not?
Yeah, thanks, Shannon. I love this question because I find this question to be really empowering, right? I mean, it underscores the concept of the law being this tool that we can access, and we don't have to sit back in fear, right? We, as queer parents, we have the power to do something now to protect our families. And I want to talk about what that something is, and I want to talk about parentage. So parentage is the idea of, or it's a legal relationship. That's what it is. It's a legal relationship between a parent and a child. And it's what provides that legal security. It's really important, right? It's where we see a lot of rights and responsibilities coming from: medical and educational decision-making, health insurance, social security benefits, inheritance, so much, right? The security that comes from legal parentage is essential to family well-being and to children's well-being. And ultimately, what you want is you want to make sure that your parentage is recognized both in your home state and also across the United States. And that's why it's so important to get a court judgment or a judgment equivalent, because under the full faith and credit principles of the US Constitution, these orders must be recognized across all 50 states.
And one question that we've gotten several times actually in the Q&A is, so sometimes they have a choice between either doing an adoption and getting an adoption decree, or, for example, if you're married and you have a child during the course of the marriage, you can just go to court and get an order confirming, declaring that you're a parent. Do you have any thoughts for people on, is one better than the other? Should they do one or the other?
Yeah, we are getting a lot of questions about that. And I think, when it comes down to it, right, families are formed in so many different ways. And regardless of how your family is formed, really it's the security that's the key concern here. And so how do you get that security, right? You can get it in a few different ways. Recently, we've been seeing greater access to different paths to parentage, whether that's, marital presumptions or holding out or parents through assisted reproduction, right? We're seeing that development in the law and in the states of more avenues to be recognized as a parent. But, without that order, without that judgment, your parentage might be questioned or challenged or, unrecognized across state lines. And so really that court order or that judgment is going to provide the most security. And what you raised, Shannon, is kind of these like two different ideas, what I like to think of as two different buckets of court orders, right? So we have adoption and we have a parentage order, and they both result in that court order, right? And that's the key piece for that full faith and credit. That's that key piece for recognition across state lines. So I want to talk to you about a little bit about what each of those is, so you can have a better understanding about it. So many people are familiar with the idea of adoption. There's a lot of terms that we hear associated with adoption, particularly for LGBTQ couples, right? You might hear second parent adoption, step parent adoption for married folks, co-parent, partner adoption, confirmatory adoption, right? A lot of terms associated with adoption. And some of these terms and some of that language might not feel great, right? I know from my own experience when I was going through the step parent adoption process, because my wife and I were married, I had this kind of pushback to it, right? Like, I'm not a step parent. I'm this child's parent. And it felt hard to come ask a court to say, recognize this relationship. It felt frustrating to me. And somebody said to me at that point in time, Meg, I'm really sorry that we live at a time that this is necessary, but I'm thankful that we live in a time that this is possible. And that really helped reframe how I thought about this, right? This is a step that I can take to secure my family. And that's the important piece, right? Is that we come out of it with that court order that says we are together, we are secure. And who adopts? Usually it's the non-genetic parent. Sometimes in cases of reciprocal IVF, sometimes it's both parents. You might want to talk to an attorney in your state about what's the best option for you based on your facts and circumstances. So that's adoption, right? So that's the one bucket of the court orders. Now we're going to talk about the other one, right? So parentage orders. These are available in some states, right? And they can confirm legal security. They're very affirming to folks, right? Because it starts with this premise of you are the parent, and we're going to give you that order that confirms that, and that gives you that extra layer of security. And often it can be a faster process or a more streamlined process than adoption. And in some states, you can actually do it pre-birth. And I know for many people that's very comforting, because that order will kick in the second that child is born, right? No gaps. There's your legal security. The child's born, it's there. You can, in some places, you can also get these parentage orders if you are a non-genetic parent and you are engaged in the act of parenting, right? Like maybe you haven't done assisted reproduction. You can go through the family court system and get an order that says, hey, you are sometimes we call it de facto parent, right? You are a parent of this child. And there are even some states that offer multi-parent recognition, right? So there's a few different ways to get those parentage orders. The process for adoption or parentage orders, those are going to differ, right? They differ even within each state of what you have to do for each of those. We are seeing states really trying to streamline these processes for LGBTQ parents, whether that's an easier second parent adoption process or a parentage order that's very straightforward and streamlined, or confirmatory adoption, right? That's confirming who you are already as a parent. And which order to choose, right? Like that's one of the questions you asked. Do I choose adoption? Do I choose parentage? It's gonna, that's gonna be an individual choice. Like what feels good to you? What are you considering in terms of time or cost or process? You might want to talk to somebody about that, but at the end of the day, they are both court orders, right? They are both court orders entitled to full faith and credit. Now, I don't want to leave this without talking about judgment equivalence, right? Because that's also really important. You might have heard the term voluntary acknowledgement of parentage, or maybe voluntary acknowledgement of paternity, right? Which is what we used for a long time when they were available to different sex couples. Well, many states are updating this to make them available to same-sex couples who use assisted reproduction. And this is really important because it's the equivalent of a court order. It's fast, it's usually free, and federal law says that these must be afforded full faith and credit, so recognized and enforced across state lines as well, right? So there are many different ways to secure that parentage, and that is what's most important, is having that legal security.
Meg, someone asked, I think this is an area of great confusion, so I think it's okay for us to dwell on it just a little bit. Someone asked a question, can we, if we're both on the birth certificate, can we just rely on that? Isn't being listed as a parent on a birth certificate good enough?
Yeah, this is an area of great confusion, right? And I'm going to touch on that area of confusion first, and then kind of address your birth certificate question second. So the reason it's confusing to so many people is because we have this patchwork of laws, right? This patchwork of parentage laws across the United States. Family law is predominantly a state's law issue, and that actually can be very encouraging and validating, because often we can access these rights and privileges and benefits and securities through our state, through state law. So that's wonderful. And at the same time, sometimes it can be hard for people to know what's available in my state. What choices do I have? What can I do? There are a lot of resources that are out there that can really help you understand what's available in your state. I know Movement Advancement Project does these phenomenal maps that show you can look at each state and find out what can you do for adoption, what can you do for parentage orders, what are you recognized for assisted reproduction, right? So many different ways that you can see your rights. GLAD Law has fantastic resources on voluntary acknowledgements, on parentage and adoption generally. In New England, it's like down to the detail. So, I mean, definitely check out those resources. Family equality also, we have a resource on second parent adoption, on voluntary acknowledgements, and then we keep a blog to keep people up to date with what's happening in family law. And then NCLR, they have also this collaboration with LGBTQ Bar Association, something called the Family Law Institute, they have a clickable map where you can click on your state and find somebody in your state, a lawyer in your state familiar with these issues to help talk you through this process. So, if you're confused, it is not on you. It is because there are so many differences out there. And so, but you'll have the resources to find those answers. Now, about the birth certificate question. As Mary touched on, part of these like constellation of benefits for folks who are married is that they get to both be on the birth certificate. And that is wonderful, right? Because birth certificates are important. They're great, they're legal, they're records, and they evidence parentage. But I think one really, really important distinction is that birth certificates in and of themselves do not establish legal parentage. And again, for some of the reasons that we've touched on, for some of the reasons that Mary touched on, these outdated laws, this discrimination that we all know exists, relying on a birth certificate or even a presumption alone really can leave that parent-child relationship vulnerable. And that's why we're really saying that the best way to get that legal security for your family is through an adoption, a parentage order, voluntary acknowledgement, right? Those are going to be your proof of legal parentage that must be respected in all states.
Okay, so just make sure we got it. So just relying just on being married, it's not enough. You need to go get a court order, right? And just being on the birth certificate, not enough. You need to go get a court order. Okay, got it. Meg, what about, we got a ton of questions from people, transgender people or partners of transgender people. So one of the many, it's one of the many, and then you try this one, and then we'll segue to Nesta to pick this thread up. But does going through a gender transition, is that going to undermine or jeopardize your legal parentage of your child?
Yeah, so again, another great question. I'm glad that we're going to have Nesta on here talking a lot about issues for trans parents, because these are really important issues, and the trans community is, feeling really vulnerable right now with this transition of power. At the end of the day, it should not, right? If you've changed your name since you've gotten your parentage order or since the order has been issued, there might be an avenue for you to amend that parentage order so that it aligns with your identification documents. And that might be helpful or useful to you, right? To have that clarity for folks, right? If folks are looking to, it's going to eliminate questions that people might have. It's going to get ahead of issues. In the meantime, or alternatively, if your parentage orders and your identification documents don't align, you can get copies. You should have those physical copies of the order, physical copies of your name change order, maybe scanned copies of your new and old ID, and keep these in a safe place, or have electronic copies with you on your phone. I laughed when Mary was like, have your documents and have them in place, because I also have my documents. I have them in like 5 places and on my phone. I think as lawyers, we're trained to be cautious. But, in today's day and age, I think it's always good to know that you have the power to have that on you, to have those documents, and to say, if anybody gives you pushback, no, you listen to me. I know my rights. I know my legal security. I know who I am to this child and to my family, and you better recognize it.
I love that. Thank you, Megan. I'll just say, in order to find out like what's going on in your state, what's the law in your state, and also to recapitulate a lot of this information that we're sharing, we do have tons of resources to share with you all. The stuff is all written down, so you can sit and look at it. And if you have more questions, come back to any or all of us, including wonderful resource from MAP that shows you the laws of all 50 states relevant to all these questions. So that's gonna be available. Everybody who's on here now will get an email with a bunch of resources attached to it. Oh Lordy, Nesta, we have a ton of questions about transgender related issues, and probably definitely more than we're gonna be able to get to, I think, but let's touch on as many as we can. But are there just general things, Nesta, that you think transgender parents should be thinking about right now?
I would be thinking about ensuring that to borrow Meg's buckets, 3 buckets, that my identity, my relationships, and my wishes are legally clear, respected, and protected. So essentially ensuring that I can care for my children or my partner access healthcare, and also access financial resources in the event of an emergency. We always encourage people to prepare in advance to avoid having to scramble in a crisis, because you're likely to be stressed and time may be essential. So again, echoing Meg, keep copies of all of your important documents in a safe place, have electronic copies on your phone, and for medical documents, you may want to have those on file with your doctors. Medical documents would include advanced directives and a medical power of attorney. You may also want to arrange, want to also have a will, both you and your partner, and potentially a financial power of attorney. And ensure that your medical documents, ensure that you will continue to receive trans health care. For example, if you were in a coma and you still want to receive trans health care, ensure that that is clearly spelled out. And there are a bunch of websites available where you can find information to help you create some of these documents. One of those that we would suggest you check out is caringinfo.org.
Nesta, what about validity of marriage? If you're married and you transition after you get married, does that affect the validity of your marriage?
So there is, fortunately, incredibly strong legal precedent that a marriage cannot be invalidated retroactively after the fact if it was validly entered into at the time of the marriage. So that is extremely unlikely.
What then should people, if you transitioned after you married, should you go back and try to change your marriage certificate to reflect your current correct name?
If you can, it's certainly a step worth considering. Just generally speaking, of course, having correct and consistent information on all of your documents is ideal. In many states, however, a marriage license can only be changed as a correction, only if there was something incorrect at the time of the marriage. So you want to look at the exact language of the law in your state. If only corrections are allowed, you may not be able to change it if the name and gender marker were accurate at the time that the license was created. That being said, if you are already identifying as trans or using your chosen name informally at the time of marriage, an argument could be made that it was incorrect at the time of creation. There may be other creative legal workarounds. We do see things like, for example, for vehicle titles and property deeds, we see people selling things to themselves for $1 to get a new title or deed reflecting the correct name. So speak to an attorney in your jurisdiction about what your options are.
What about, same question basically for your child's birth certificate? If that predates your transition, should you try to go back and get the child's birth certificate altered to reflect your post-transition name, etc.?
Same answer, basically. If you can, again, totally, absolutely worth considering, but similarly, birth certificates often can only be corrected if there was an error at the time of its creation. However, often new birth certificates are issued following an adoption. So if you are a trans parent and you are pursuing an adoption, you may be able to squeeze in a name change in connection with the adoption to get the birth certificate to have the correct information.
What about if you're transgender, can that be used against you in a divorce or custody case or in a child protective services case?
So in theory, all United States jurisdictions are bound by state law and/or court precedent and/or ethical rules not to discriminate on the basis of sexual orientation, often gender identity and expression. In practice, judges are humans and bias, unfortunately, does happen. In the custody context, I will say that family court judges typically are very motivated to do what is in the best interest of the kids. And when they are shown the overwhelming evidence that having a transgender parent is not harmful, but being separated from a parent is extremely harmful, judges tend to listen. Now, a former partner or their lawyers may try to use your trans identity or your being in the process of transitioning against you, maybe in a veiled way by talking about stability for the children being confused, the children being exposed to a lifestyle. We also sometimes see this, but with bisexual parents in same-sex relationships, raising kids from previous different sex relationships. And you may also encounter bias or a lack of cultural competence in other professionals like forensic evaluators, attorneys for children. And that is why, again, it is extremely important to have an experienced attorney who is familiar with these tactics and can counter them by educating the court in real time, and can also make a good record for appeal if the decision reflects bias.
Yeah, I would just say, oh, sorry if I don't mind me jumping. Like for the longest time, anytime a lesbian or gay parent or bisexual parent was in a custody dispute, we would strongly encourage them to reach out to our groups to be prepared to put on expert testimony that your sexual orientation isn't relevant to parenting. That has mostly and not really been necessary now for some time because there's so much more acceptance and courts are generally okay with dealing with sexual orientation, but we're still in that place with transgender parents. I strongly advise any transgender parent in a divorce or custody dispute to reach out and be prepared to educate the court, because you could really find yourself in trouble if you don't do that. Sorry, Nesta, you were going to add something.
Oh, no worries. Thank you. I just wanted to also cover the CPS portion of the question. So it's very unlikely that CPS will file a case based purely on a parent's transitioning or being trans. That being said, queer and trans parents absolutely may encounter biased caseworkers, judges, or other professionals in the context of a CPS case. Just generally, we always encourage anyone involved with CPS to document everything. And if you learn that you are being investigated, to try, if you have the resources, to get an attorney immediately and not wait until a case is filed against you in court. Now, in most states, folks who cannot afford an attorney are entitled to a free one if the case does go to court. There are 5 states, Missouri, Vermont, Nevada, Wisconsin, and Oregon, where parents don't have an automatic right to counsel, and it's up to the judge's discretion, a case-by-case determination. So if you're in one of those 5 states and you end up with a CPS case, be sure to request an attorney early and often on the record at the first court appearance. And if your attorney does not have expertise in cases involving LGBTQ parents or children, get in touch with us. We can support them. Both NCLR and GLAAD offer what's called technical assistance, which is basically lawyers helping lawyers. I think the greater concern in the CPS context is supportive parents of trans youth being targeted. It's important to know the exact law in your state if your state has a care ban. Does it apply only to in-state providers? Does it apply to parents helping kids access care? Texas did redefine child abuse to include providing health care to trans youth and tried to require CPS to investigate affirming parents. That was immediately challenged, and the court issued an injunction blocking CPS from opening new investigations based solely on that, and also requiring them to close cases that were based solely on that. So every legitimate professional organization is opposed to the enactment of these kinds of policies. The Child Welfare League of America, the National Association of Social Work, American Psychological Association, the American Medical Association, the American Academy of Pediatrics, everybody who knows anything is very clear that support is not abuse. So know that we are watching, and we will be there to fight if other states try this.
Nessa, can you just briefly say what CPS is in case people don't know?
Child Protective Services.
Which means like somebody's accusing you of abusing or neglecting your child, and the state comes in and
Exactly.
take
So
your
if
child away.
you are
Yeah.
being accused of abuse or neglect, and that could be a mandated reporter or just a member of the public trying to call in a case out of legitimate concern or maliciously.
All righty, we've got a bunch of questions, so many good questions, and we're running out of time, but let's try to get some of them. Should people who live in DC, families in DC, feel particularly worried? This is for anybody, you know, given that Congress, it's a federal district and Congress can mess around with DC law. What do y'all think, panelists? Anybody worried about LGBT families in DC? That's a hard question.
Yeah, I mean, I guess my answer would be they certainly could. I don't have a fantastic read on the likelihood of Congress acting to restrict protections. Folks in DC right now enjoy some really fantastic rights and protections, and hopefully Congress will be too busy doing their actual jobs.
Yeah, I mean, you still get protected by the Respect for Marriage Act. You should still take all the steps that everyone should take with the wills and power of attorney in case there's a problem with your marriage. It's just something I don't know. I don't think there is a definitive answer, probably because we don't, yeah, because of what Nesta just said, we don't know what the heck they might or might not do. Hopefully they won't resort to that level of micro targeted harm, but we shall see. Here's a
Shannon,
question.
can
Mary,
Can I jump in on that quickly? Yeah,
yeah,
and years
please.
and years and years ago, Congress tried to do something that was family related around kids in DC, and it was the proverbial hornet's nest. And I have to say, like, they're going to have enough stuff coming at them, and plus they have their own affirmative agenda. So I'd like to think that DC is not going to be high on the list. And everything everybody talked about that's a good idea to do is a good idea to do, no matter where you live, including DC.
Mary, what about this one? If federal protections for marriage are removed, which as you say, we cannot let that happen, but are there any steps a married couple should take if traveling to a state that may not recognize our marriage?
Yep. So first of all, if Alberta were reversed, the Respect for Marriage Act is still here. So your marriage should be respected from state to state. That's why you want be able to have your marriage certificate available to you. But having said that, we all know that there's the document and then there's people who seem not to understand it or don't understand who you are, and like it just doesn't compute. And therefore, yeah, you got to think in advance about everything you can have and who you need to have on speed dial. And you know, if you're needing medical care as you travel, to make sure your PCP maybe knows about that and can point you in the right direction, should you have a medical event. So yeah, I think there's things like we have to do the belt and suspenders because we're going to go through a weird time here and we're going to come out on the other side eventually.
Thank you. Yes, we will. Here, this is a question we're all getting a lot. Is it worth changing a transgender child's gender marker on their passport now, or does that just create a paper trail that we will regret later? Anybody want to tackle that one?
So interestingly, I was on a call earlier this week where apparently Department of State doesn't actually say that they can identify markers that were changed. I think an X marker is a different question because that's very easy to identify. But if you have changed or are thinking about changing your passport, you know, I know they're also trying to expedite those now before January 20th. So I think, you know, the paper trail is less of an issue right now, at least the way we understand things.
That is really valuable information. Yeah, because I would say, yes, it's such a powerful document to have, and it's just generally helpful to have a federally issued document that reflects your child's identity. So that's wonderful. That's so good to know, Naomi. Thank you. Naomi, sorry. I know your name. Sorry. I'm just old. Sorry.
Just to add on to that, on a note on the X gender markers, we absolutely recognize that, you know, for non-binary folks, that may be the most accurate marker and most accurately reflects your identity. And we just encourage people to, you know, think about situations where it could present an issue, where they might encounter discrimination or harassment, and really weigh what is the right decision for them individually, knowing that that marker may unfortunately put a target on you in the future.
I will just say that Glad Law's Transgender Rights Project just put out some fabulous materials on these types of questions. I strongly encourage anyone who's got questions, transgender, non-binary, you know, what should I do with my ID documents? We'll send you a link everybody who's on here a link to those, but boy, those are super helpful. And they list like some of the things you might want to, questions you might want to ask yourself and considerations so you can make, just an intelligent, informed decision about what makes the most sense for you. Here's a really good question. Do wills in life and estate planning transfer across state lines? Meg, I'm looking at you, but anybody?
I mean, you can look at me. I'm not an estate planning lawyer, so I'm going to kind of put that caveat out there. But my understanding is that your will is your will, and your guardianship provisions are your guardianship provisions. But I can let Mary weigh in on that, since Mary was the first to encourage people to do those documents as well.
Yeah, I mean, I'm straining to remember this, so maybe it's the kind of thing we should put in the follow-up document too, Shannon, just to get the right answer to that question.
And
But
I
I think,
think my
yeah, that's probably the
brief
best thing to do.
answer would be that a lot of times if you have a will from another state that doesn't perfectly map onto the requirements for your new state, it's not that that will is just going to be thrown out, but you may have to go before a probate court, and the process may be more drawn out and more complicated than it would be if you were in total compliance with the new state's procedures.
Mary, is that your recollection or?
Yeah, I think it might be all or nothing in some places, but I hear Nesta that I think people don't want to invalidate a will. Judges don't want to invalidate a will. It's very important that somebody did a will. And I think we'll often struggle to try to find a way to execute it, follow through on it as much as possible. But yeah, more process. And it made, yeah, anyway, I'll say no more other than I kind of want to do more research.
I agree, and I would strongly advise, if you made your will in one state and you've moved to a different state, I would strongly advise that you consult an estate attorney in your new state to make sure it meets the requirements in your new state. That does lead kind of directly to this question, which is an important one. What kind of help is available for people who can't afford to hire attorneys to handle either these parentage orders or adoption or estate planning?
Yeah, so I'll start with that question. So I think that there's a number of different options and resources, and I understand that's really intimidating for people when they're hearing all of these legal options or legal recommendations, and they are unfamiliar with the law and they don't know how to hire an attorney or who to hire or if they can afford one. I think there's a few different things that you can consider. One is that there might be legal help that's accessible to you, whether that's through GLAD's Answers or NCLR's helpline or some of the other options there. There also might be some attorneys who are willing to provide some pro bono or low bono representation to folks. And then there are also, like we talked about, the resources that talk about what your options are in each state. Some of these are really accessible. Voluntary acknowledgements, really accessible. It's a form often provided at the hospital, and you don't need an attorney to sign off on those. So, there are things that you can do without an attorney. In some of these cases too, or in some, you can do it you can self-represent, right? You don't have to have an attorney in every case when you're doing even an adoption or a parentage judgment, right? You can be self-represented. And there are some times that you can get information even from the court. Sometimes they'll give you a packet on what do I need to file and how do I do it. Also keep in mind that, some of the costs associated if you're self-represented are going to be things like filing fees. And in many states, you can request a waiver of those fees. If you struggle to afford the filing fee, you can ask the clerk or ask the court if there's a waiver available that you can fill out and see if they can waive those costs for you. And don't be ashamed to do that. People do that all the time. So, don't let cost be that barrier to accessing the protections.
We got so many more questions in the Q&A chat. Here's one. My girlfriend is not on my child's birth certificate by choice. I have a trust and medical paperwork for me. Does that follow to my daughter if something happens to me and I can't make decisions for her, or does she need her own paperwork since my girlfriend wouldn't be recognized as a legal parent since she's not a legal parent?
So if I'm understanding the question correctly, and your girlfriend was not a genetic or a gestational parent, then we would encourage, because again, being on the birth certificate is helpful, but is not legally conclusive. So we would encourage you to, encourage her to pursue an adoption or a parentage order.
Very good. Nesta, this is a very specific one for PA. My husband and I have a joint petition for assisted conception birth registration here in PA. Is that the same as a parentage order? A joint,
Yes.
okay, good, good. Boy, I think we're actually almost completely out of time, but yeah, Nesta, I know there's some closing remarks you need to make, so I probably better let you do that.
Thanks so much, Shannon. We received so many questions from you all, both at the time that you were registering and in real time during this program, and we have answered as many as possible, and also want to acknowledge that we know that parents, children, and allies have so many more questions. So please stay tuned for announcements regarding additional programs, including programs for parents of queer and trans youth and for children of LGBTQ+ parents. In the meantime, please check out all of our websites for resources. Family Equality has great peer support spaces for folks who want and need community. MAP, the acronym, is what's on the tin. It has absolutely fantastic maps to understand the law in your jurisdiction. And we also encourage folks to visit Collage. They contributed to a parentage report, the parentage report you will be receiving as part of your material. They're the only national nonprofit by and for children of LGBTQ+ parents. And you can find helpful resources and a supportive community there if that describes you.
Sorry, I'm just looking through all these great questions. I know we're just almost totally out of time. If we can't, we're not going to get to, we just can't. It's not physically possible to get to every single. There's like 76 questions in the queue here, but I don't want anyone to go away without your question being answered. You can call or email the helplines at NCLR or GLAD Law, and we will definitely get back to you and answer your specific question. In the little teeny moment we have left, though, I wonder, Mary, someone asked, how does Project 2025 undermine marriage equality? I wonder, do you want to just like briefly address that?
Sure. Project 2025 has a vision of trying to just sort of stop talking about gender, stop talking about same-sex couples, stop talking about LGBTQ anything, sex, gender, CRT, systemic oppression. So there's that kind of thing. And I think actually, the Trump administration has not come out swinging, or the new incoming administration has not yet come out swinging on this, although there are many people in it who are no friends of ours. I think, the time will tell, but I think one of the biggest threats we have is just the many groups that helped to create Project 2025, virtually all of whom have weighed in hard repeatedly against us on non-discrimination, on marriage, on trans everything. So, the Supreme Court and the Trump administration is one thing. That's Trump administration's executive branch, but it doesn't prevent our many detractors from figuring out a way to engineer, cook up new cases to try to put things in play.
I'm just saying, I know we got to wrap up here that we're facing a lot of hostility for sure. And there are some powerful people out there who are very hostile to our families and want to undo marriage equality and other protections. But I hope one thing came through here is that our marriages, we absolutely can protect our marriages. We have so many ways to do that between Obergefell, Respect for Marriage Act. And as long as there are some states in this country where people can marry, we're going to be okay. And so I don't think anyone needs to worry about either the validity of their currently existing marriage or their ability to marry in the future. And the same does go for parentage protections. If you will get a court order, you're going to be okay. That's going to be respected and protected. And for unmarried couples, if you do the things that we're recommending you do get power of attorney for healthcare and finances. Make sure you have a will. That is generally going to be respected. So that is kind of the good news on the family protection front, that there are actually things that we can do that will genuinely protect our families, even in the face of a whole lot of hostility. And so that is important. Mary, do you have any closing thoughts for anybody?
You know, Shannon, I actually really appreciate what you said, which is there's always going to be a path forward here. And that's true on the marriage protections. And even though things I think are going to get super difficult, it's going to be true generally. We're going to find a way forward.
Anyone have any other closing thoughts before we let folks go?
I think my closing thought would be that, you know, queer people, we are smart, we are resilient, right? We come together and we're not going to let this stop us, right? We've been working on these issues well before this administration was, well before Trump was elected, right? These are not sudden things that we're thinking about. We have been thinking about this. We've been planning for what to do to protect each other and our families, and we're in this together, and we're going to be fine.
Well, thank all of you for joining us. Thank you to NCLR and Glad Law and Family Equality. You all really are the dream team. And I hope that everyone who's watching today really does feel supported by all of these amazing organizations. They have helplines, they are doing advocacy and policy work, they are fighting in the courts for you, and will continue to do that. And thank you so much. As a queer mom, I really appreciate all of you.
Thank you all.
Hi, everyone. Thank you.
Thank you, everyone. Hope you feel supported and empowered. We are here for you.